And now to our interview segment. My guest, Professor Fidelis Oditah, was educated at the Universities of Lagos and Oxford. He's a Queen's Counsel in England, a senior advocate of Nigeria, a bencher of Lincoln's Inn, and a visiting professor at the University of Oxford. He has advised and handled matters for the federal government, ministries, oil companies, and multinationals. Professor Oditah joins me on the program now. Prof, thank you for talking to us.
It's my pleasure.
The judiciary, particularly the bench, has come under serious criticism lately for various reasons. The Chief Justice of Nigeria recently alluded to it, especially with regards to election matters. But what are your thoughts on the judgments that we see coming out of the Supreme Court lately?
One has to be sympathetic to the judiciary and be circumspect in condemning the judiciary. In addition to that, like most institutions in Nigeria, the judiciary is a subject of poor funding, lack of motivation. The recruitment of judges has not been the best. And so the weaknesses which we see in many institutions also afflict the judiciary. And one has to appraise their performance in that context, given the constraints that they operate under. I know that in December last year, when I went to speak to some of the judges on Anti-Corruption Day on the 9th of December, some of them hadn't been paid for 2 or 3 months. And one has to bear that in mind in saying that the courts are inefficient and the people take bribe. How do you leave an adult man or woman with a family, a senior public official, without payment for 2 or 3 months? It's just a disgrace. It should never happen. But it's just another aspect of our own failing as a nation. Having said all that, yes, the Chief Justice of Nigeria did say recently that it was unfair to single out the judiciary. Perhaps he has a point. But it must be said also that the judiciary is being funded with public monies, and therefore they are subject to public scrutiny, and they should be subject to legitimate criticism. There's absolutely no reason why they shouldn't be criticized, provided the criticisms are constructive and well-founded. The courts have shown particular vulnerability to election cases, and I think it's because of a political pressure which they bring to bear on them. In some cases it's not about money per se, it's also about peddling of influence. But the courts have encouraged, unwittingly, electoral malpractices. Not in the sense in which President Buhari said when he was in Kenya or somewhere in East Africa a few weeks ago that 3 times he was prevented from being president by the Nigerian judiciary, because that assumes that he won on those occasions. The system may be imperfect, but there is no proof or sufficient proof that he had the national coverage to have been declared winner. There are other reasons why he should feel aggrieved in relation to what happened to his election petitions on those 3 previous occasions, for example, the delay. But some of those issues have been addressed by putting time limits on election petitions. But I think it's somewhat presumptuous to assume that he won on those occasions and he was prevented from being declared the victor by the judiciary. And I do recall, particularly the 2007 election petition, he came very close. It was a very close Supreme Court, 4-3. 4 were in favor of Yar'Adua and 3 were in his favor. But those who were in his favor did not say he won. What those who were in his favor said was that the elections were marred by irregularities such that they lost the character of fair and free elections, and therefore there should be a rerun rather than having to be declared the winner himself. And more recently, the issue of overvoting, INEC has tried to address through card reader accreditation. And we know in the last election the card readers were used. Sometimes they failed due to mechanical and other faults. Sometimes they were sabotaged deliberately by those who were interested in manual accreditation, which would enable them to write the election results, give rise to overvoting, and so on. And it's a bit disappointing to see that the Supreme Court did not protect that system as much as one would have expected. And indeed, as I said, it's unwittingly encouraged electoral malpractices, because in some of the states where the Supreme Court has now dismissed the appeals or rather allow the appeals and then confirm the governors who were declared by INEC, it does appear to give the impression that what matters is to be declared the winner. How you win does not count at all.
You've alluded to the decisions that we've seen, the conflicting decisions on card readers. It has continued to generate controversy, but is it not a setback to achieving transparent elections? And some people have said that perhaps we would have to amend the Electoral Act and the Constitution.
I think in a mature system of civil justice system, you can achieve most results without amendment of legislation. Sometimes we over-legislate in Nigeria. Everything is law. Everything you want a new law. It's not so much the existence or the lack of laws that has constrained the development of our system. It's the refusal of the operators to abide by the rules. And also it's partly the failing of institutions. We know that in a number of cases, the card readers did not work. So why should we enshrine in our law something which might not work? The solution might create a bigger problem than the problem it is seeking to address. I don't particularly agree that one needs to legislate for everything. I think that the framework of electoral laws is sufficiently robust to deal with these issues. What is required is more cooperation and understanding from those who are charged with interpreting the laws. But we haven't seen the reasons why the Supreme Court gave those verdicts, and we need to wait for them to see what its own thinking is in relation to the use of card readers. I dare say that every Nigerian is interested in the development of our democracy, and I'll be surprised if the Supreme Court unwittingly or wittingly took steps which would undermine the development of our democracy, of which the use of card readers to improve transparency and to eliminate ghost voters and overvoting is a part.
What would you say to those who believe that the reason and the judgment should have come together?
Yes, of course, in an ideal world, the judgment and the reasons should come together. And in a country like this, one should be a little worried where reasons come later, because there are instances where the reasons come later, where the courts have appeared to adjust their reasons so as to reflect the criticisms which are in the public domain. And that is most unfortunate. But I'm not sure that that is why the Supreme Court has announced the results and then said it will give reasons. Elsewhere, the courts do that. In the United Kingdom, they do that, but it's more the exception. It's very rare. And it's done in very urgent appeals where the result has to be given almost immediately for reasons to be given later. In the case of the election petitions, election appeals to the Supreme Court, it is possible, I don't know the facts, but it is possible that the Supreme Court was constrained by the constitutional timetable for delivering judgment. And I think also in 2011 petitions, a number of appeals were disposed of for reasons to be given later. Indeed, what the Supreme Court said on those occasions was that while the Supreme Court as a final court is free to do that, the Court of Appeal could not do that and reversed a number of appeals on that basis. So I don't think one should be unduly worried that they've given, they've announced the results without giving the reasons, because after all, the Supreme Court is the final court. Whether the reasons are good or bad, they are the Supreme Court's reasons, and there is no further appeal from them.
Another reason why the judiciary is being seriously criticized is for their role in the anti-graft war, and you've already alluded to that. But more often than not, lawyers will say that there are more upright judges than there are corrupt ones. So I'm wondering, is it an image and perception issue?
Like every other aspect of human life, bad news spreads very quickly. Good news doesn't spread. So if you do a good thing today, no one is going to hear. But if you do a bad thing today, it's going to go out like wildfire. It will be tweeted and retweeted several times. Whereas if it's positive news, people say it's boring. It's not sensational. And so there's a tendency to over-focus on the bad news than on the good news. And I think that that's is an aspect which the judiciary has been subjected to. But having said that, there is no doubt that the courts have felt enormous pressure in relation to big cases, whether they are big white-collar crime cases, whether they are big cases involving bank directors, whether they are big cases involving politicians. They have felt enormous pressure. And the lawyers have also abused the system, because prior to the coming into effect of the Administration of Criminal Justice Act 2015, there was widespread misuse of interlocutory applications. Most of the cases just got bogged down with interlocutory applications, interlocutory appeals. You could have, this morning I was reading some of interlocutory appeals that went to the Supreme Court on some issues of small procedure. And so when you have a case go to the Supreme Court, the result of which is that for 5 or 6 years, nothing has happened. Oftentimes, the public does not know that. The public blames the trial court, but there's nothing the trial court can do. If, as a matter of civil law jurisprudence, a person is entitled to appeal a decision, it is almost inevitable that the lawyer will appeal it. Why would you want your client to be behind bars if he can enjoy some freedom through the use of interlocutory appeals? It is just the case. But now we see there is some change. Some changes have been brought about by the Administration of Criminal Justice Act. For example, Section 306, which says the criminal trial cannot be stayed. Section 396, which enjoins the courts to sit from day to day, and so on. Those are parts of the machinery to improve the administration of criminal justice. But the courts themselves, especially the appellate courts, have a large role to play, because oftentimes the appellate courts interfere with the case management powers exercised by the trial court. A trial court might decide, for example, that an amendment should be made, and the person affected might go on appeal. The Court of Appeal might reverse it. And then the other side might then take it up to the Supreme Court. And so you ask yourself, why should an issue such an amendment go all the way to the Supreme Court as an interlocutory issue, whereas the substantive issue has not been done? Why isn't it better to take that issue alongside the substantive issues and deal with all of them at the same time, so that whoever is aggrieved at the end might appeal all the issues? Because whilst, of course, in certain circumstances, you do benefit from wise use of interlocutory procedure, we've seen here that there's widespread misuse and abuse of interlocutory procedures, and so one should try, to the extent possible.
Some people and some retired judges I've talked to think that perhaps the time has come for judges to come out to defend themselves, especially with regards to some of these criticisms and when allegations are made against them. But what's your take?
I don't think that the judiciary should be reduced to the level where the judges come and defend themselves publicly and say, this is why I did this. There is a forum for that. That's why you have people commenting on cases. And in every system of law, whether it's Nigeria, United Kingdom, United States, they have learned journals where people comment on cases. And so that is one forum for commenting on judicial decisions. And the judges should take the opportunity to explain why they think that their decision is correct. Many judges do so abroad. So they pen it down. They write their judgments, and then someone criticizes the judgment. They might write an article explaining how the law is the way they interpreted it. I think that is a more constructive way to engage and to respond than to come on television and say, people have criticized me for acquitting James Ibori. I did so because of X, Y, Z. Really, I think it's belittling the judiciary and perhaps bringing the administration of justice to disrepute for judges to come publicly to be debating with journalists as to why particular decisions were made. But really, I think that there is never going to be an occasion for that. The fact of the matter is that the quality of the judiciary has diminished over time, just like the quality of all public institutions in Nigeria. And one should not feel too surprised about that. We have reduced everything to lobbying, and because a system which is based on lobbying and not based on merit will suffer. And so we're seeing some of the adverse consequences of decades of lobbying and recruiting inappropriate personnel into the judiciary. Clearly, many of them are very able. Many of them are very dedicated. And I've seen fantastic judges who compare with any judge anywhere in the world. But sadly, I've also seen many judges who have no business being called judges. And it is great reluctance that you call them my lord or my lady, because they have no lordship quality or ladyship quality whatsoever. But you are constrained by convention to address them, not for their own dignity, but for the dignity of the office which they have been put inappropriately and unwisely. And so one has to try and see how we might reform the recruitment of judges, and apart from that, see how we can reduce the excessively procedural nature of Nigerian law, because as I often say, Nigerian law is excessively self-indulgent. No system can be so obsessed with procedure as we are.
The Nigerian judiciary indeed has more upright judges and only a few corrupt ones, but there is a need for reforms. The country needs to pay particular attention to the mode of appointment of judges, fund the judicial sector better, and provide them with the necessary infrastructure to do their work properly. These are just a few suggestions from my guest, Professor Oditah, QCSAN. What do you think? Please share your thoughts, comments, and questions using any of our social media handles. If you missed any part of this program, you can find it in past episodes on our YouTube channel. I'm Shola Sheyeli. Thank you for watching.